Most of them don't win, but even the ones that win, the result is that the judge says, well, that decision was unlawful and the council has to remake the decision. If the council remakes the decision, taking into account all the things the judge has said that they should think about, but in the end comes to the same decision, then you don't get a challenge in law. So it's and that, for one of the recent examples of a case that argued that the consultation was unlawful was against Haringey, a case called M and Haringey, where Ms M and Ms S were both saying that Haringey's decision to bring in the 10% contribution for council tax and the end of the 100% council tax benefit. Again, they weren't saying that that was wrong in itself because that's a government decision, but they were saying that the council had failed to consult properly. And the judge looked at it and said, well, I think the consultation process was lawful. Doesn't mean the judge agreed with it, but he thought it was lawful. So generally, that's what's happened. You lose, and even if you win, the council just has to take the decision again. Individual justice, as I say, can be obtained for people in specific circumstances, but it's not going to bring the government crashing down to its knees. And it's hardly surprising that judges on the whole tend not to want to start attacking the government's policy politically. I'll let you all think about why that might be. The class nature of where judges come from, the fact that English law is based on property rights and deference to government, and the fact that, and this is a more political point, that it's not actually for judges to start deciding whether or not parliamentary actions are right. If we had, heaven help us, a decent social democratic or even socialist government in the next few years, I can't see one coming along immediately, but we have to hope, we would not want right-wing judges striking down what with widespread equality laws, for example, or laws that produced widespread redistribution of wealth, and they might well want to do so. So there is something to be said for judges actually not going too much into the political arena. So judicial reviews can be great. The funding is very, very difficult to get. It will be even more difficult post-April when the legal aid cuts come into effect. The reason why lawyers talk about legal aid cuts so much is not because we are talking about our livelihoods. We could all probably get different jobs if we needed to, but it's because legal aid is something that allows poor people to stand up for their rights, and these legal aid cuts directly affect the poorest in our society, who will no longer be helped to stand up for their rights through the legal process. It doesn't mean they won't do it in other ways. What about what's going to happen in the courts when we have possession cases brought on the basis of rent arrears because of the bedroom tax? Well, several points to make. The first is that for private rented tenants at the moment, if the landlord decides that because you are in rent arrears, then he or she wants the property back and wants you to be evicted, the landlord has to go to court, but doesn't have to tell the judge what the reason for wanting possession is. This is for all private tenancies created since 1989. Gold dust rent at tenancies, there is still much more judicial discretion, but they're few and far between. Most private rented tenancies, then the court simply rubber stamps the landlord's decision to bring possession proceedings and doesn't have any legal way of interfering. So private tenants are already getting evicted through the court process, but without any scrutiny of why. For council and housing association tenants, then the council and the housing association, in most cases, does have to say to the court, well, there are rent arrears, and it is reasonable for us to get a possession order, and because those rent arrears are going to escalate, then we want to have what's called an outright possession order, which means that the tenant can be evicted, rather than a suspended possession order, which is the possession order hangs over the tenant, but so long as the tenant pays their rent and something towards the arrears, then they stay in their property. That's the current position. For some housing associations, then tenants who are on rent arrears, there can be a sort of no choice option in front of the courts. The court doesn't have discretion to look at it. But even with these broad discretionary decisions that judges can make for council and housing association tenants, at the moment, when do I go along to court, you've got a client who's in rent arrears, we make a lot of fuss, we take all the legal points we can, And mainly what we are doing is buying time, and the time that we buy, we work with the client to try and make sure that all the proper benefits are claimed, that debt problems are starting to be resolved, agreements made and so forth, so that you can say to the court, there were rent arrears, these were the reasons for rent arrears, but from now on the tenant will pay their current rent, the rent that they have to pay. If they're getting housing benefit, the net rent they have to pay after housing benefit, plus a contribution to the arrears. And if you can come up with that sort of plan, and if that's realistic, then courts are likely to say, yes, that's fine, they can stay in their house. That's what Wendy and I have been doing for a living for more years than either of us can remember. The problem with the bedroom tax is that lawyers aren't going to be able, and tenants aren't going to be able to say that. Because there will be some people who will be coming to court and they say, yes, I know I'm in arrears because of the bedroom tax, but I am taking steps I'm about to get a job, so I'll come off housing benefit, or someone's moving in, a lodger is moving in. I don't know to what extent. The government's great line is, well, people should be getting lodgers in for bedroom tax. Anyone who is on benefit and they have a lodger, chaos, havoc is going to happen to their benefit as a result of the income coming from the lodger, and it seems to me that the government has not thought about that. But anyway,
also subletting,
and subletting and so forth, for which you need permission. So there will be some people who will be coming to court saying, yes, there are arrears, but I can sort them realistically. But most people who are subject to the benefit tax who end up in court are going to be there saying, I'm sorry, each week I can't afford to pay the 14%, the 25%, let alone make a contribution to the arrears. And that is going to be a major problem for the tenant, primarily, because they face being evicted, for their social landlord, and social landlords don't want this, but they want as much housing benefit as possible being paid, frankly. But the social landlord is going to be saying, well, the more arrears we let people accrue, we're going to have to put up our rents, which will be paid by all the other tenants in order to balance the books for the arrears. That's the argument for social landlords. It's not one I agree with, but that's the argument. And judges are going to be saying, how can I possibly let somebody stay in their property if I know that means that the arrears are going to go up week after week? There may be some what we call soft judges who will take that approach, and there will be some very hard judges, and most judges are concerned about what they call property law. There's going to be some very hard judges who will simply say, I know this is sad, but I'm going to have to make a possession order, and not the sort that hangs over your head because you haven't got any realistic plan to pay the arrears. So that, I think, is going to be very difficult. The strategy around it is going to be very difficult and something that we need to think out. I want to end with 2 points. One is about the poll tax and one is about community resistance. Is this Cameron's poll tax? Well, maybe. It's beginning to hit the headlines about just how unjust the bedroom tax can be. And Eileen said from the platform, we should all not be paying because of solidarity. That's part of the point. With the poll, everyone was affected by the poll tax, and of course a few rich people were better off, and most people were worse off. And that meant that everybody, including even the odd rich person with a conscience, could stand up and say, I am taking a stand and I am not paying the poll tax. That is not the case with the bedroom tax. It is hitting the poorest of the poor. The people who are on housing benefit, by definition, are the poorest of the poor. And nobody else, unless you do have, across the country, council tenants en masse refusing to pay their rent, and I think that needs a much bigger campaign than we've got, the one that we've got at the moment. But if we don't have that, then it's only going to be the poorest who are going to be asked to stick their heads above the parapet, to engage in non-payment, and of course to face the risk of eviction. So I think we need to think about that very carefully indeed. I'm not saying there shouldn't be a non-payment campaign, but I'm saying it involves an awful lot of support for the people who are not paying. That's extremely important, because it's very unlikely that we're going to have mass non-payment. The other point, of course, is that Thatcher was the poll tax brought down Thatcher, and Thatcher being brought down with an end to the poll tax. That was Tory MPs getting hundreds and hundreds of letters in their constituency postbag from Tory voters who could not afford to pay the poll tax. That is not going to happen for the bedroom tax. Tory MPs probably don't care very much about how council and housing association tenants who are in receipt of housing benefit are going to vote, because they reckon that most of those people aren't voting Tory anyway. So the targeting it on the poor is clever, and it avoids that kind of home counties revolt that happened with the poll tax. So I do think we have to be very aware that the parallel is useful but not complete. I think the best parallel with the poll tax was where, and it happened more in Scotland than it did in England, but where there was mass resistance to evictions. Yeah. Warrant sales, they called them in Scotland, bailiffs' warrants, evictions, we call them here. And the woman from the platform in Liverpool talking about how mass resistance to evictions can A, prevent evictions, that's a good thing in itself, you keep someone in their home. B, it does give huge hope, and it's something all of us can do. It's not about lawyers having an argument in the courtroom and everybody else watching from outside. It involves mass participation, and I really think we should be working on a plan to resist evictions. What about councils and public sector workers working for councils? Well, the argument about whether or not Labour councils should implement cuts or not is one that's been going back to the 1980s. The argument against implementing cuts from Neil Kinnock onwards, the so-called dented shield, was, well, Labour councillors will at least protect the poorest in the community if we make these cuts, but we try and do it nicely. It's not something I ever agreed with. I stood up on Islington Council and said they were wrong 20 years ago when they were bringing in the poll tax. Because the Labour Party has now changed and most Labour councillors see their role as kind of Blairite managers, then there's very little resistance amongst Labour councils. There are some Labour councillors, and I want to know what the Green Council in Brighton and Hove is doing, because really they should be standing up. But council standing up is not, that's going to come about as a result of community campaigns, grassroots campaigns, community resistance. It's only going to happen when Labour councillors themselves feel under pressure to start standing up. They are not going to do it out of the goodness of their heart. Housing officers, people who work for the councils, I think the unions should be arguing for a conscience clause, so that housing officers who say we are not prepared to get involved in the process of getting possession orders and evictions for people who have rent arrears because of the bedroom tax, or rent arrears just because of poverty, but specifically rent arrears because of the bedroom tax, that the unions should be saying there should be conscience clauses in every contract of employment, and we will support all our members who take a stand and refuse to start possession proceedings. So there are a number of things that can be done, both with councils, with council workers, and with the trade unions. I think it is going to come down to a campaign of all of those elements, and a campaign that comes from the grassroots and comes from the community and talks clearly about resistance. But I think what we must not forget is that the people in the firing line are the poorest people in our community, and they are people who are already juggling, as so many of us are, juggling their rent bills, their food bills, and their fuel bills. And it's for those of us who are not yet in that position of thinking there, but for the grace of God, it's our job to stand up shoulder to shoulder with them, because if you're juggling food, fuel and rent every week, it's very hard indeed to be asked to stick your head above the parapet.